that if you are having trouble uploading something to the court site, one thing that's helpful to consider early on is how large your file size is. The court does have caps on file sizes. I believe right now it's 5 megabytes.
5 megabytes, that's correct.
And if you can't upload your entire document in 5 megabytes, you can upload it in portions. And that's something to consider if, for some reason, you're having trouble submitting something to the court online.
Oh, and that's a very good point. And also, another great thing that we've done over the past 6 or 7 months is we've created this naming convention now. Back in the day, you had to select whatever we called a particular document, and that's what you were stuck with, motion for summary judgment. Now you can make it more particular to your case or more specific. So you can name your pleading that you're sending to the court, so when you go back and look for it again, or it's more meaningful in the docket. So in-house, it helps us, the judges, et cetera, and the court staff to identify what you're trying to accomplish and what you're actually filing. But for you, that was a big complaint from the bar. Jerry, you might remember you saying, can we name this stuff ourselves? You know, what you have down there is a fitting. So we've changed that. So now you can name the documents yourself and submit them to the court.
I think another feature that is very helpful too is if you submit a motion package or a document or what have you, and are learning, and you don't want to preclude your client from having an opportunity because of something simple that can be rectified. Right. And I think the court's been very helpful at quickly emailing back, being available for questions, walking you through the process if necessary.
Well, thank you. And yes, that was important because we're mindful of statute of limitations and things along those lines. If we reject a pleading, it could really hurt you. Right. So you're correct. Our review clerks, we have a number of review clerks behind the scenes watching the documents as they're coming in the pathonetary's office and motions court, and if they see an error, they're emailing you saying, you know, change this or correct this or here's the problem. So
you had a question?
Point.
Yeah. When I've tried to get the e-filing office or people
watching the documents as they're coming in the pathonetary's office and motions court, and if they see an error, they're emailing you saying, you know, change this or here's the problem. So
you had a question?
Point.
Yeah. When I've tried to get the e-filing office or people there, and I call the pathonetary's office, I've been given a number, and then the last two numbers are different. You know, and when I call, I get two people's names. I don't know what number. I'm sorry, I don't have it with me. So all you can do is leave a voicemail message, and then I found out there was another number. So I don't know what the pathonetary. If you just call the general number.
If you call the pathonetary, they're probably trying to forward you to Kevin Daly or Bob White. Oh, two females? Okay.
And then, so what happened one time, one mailbox was full, the other person was on vacation. So is there a number, a better number I should be, what is the number when you want to get?
The main number to the pathonetary's office.
No, to get the e-filing.
The e-filing. Yeah, it's 215 686 665. Now that's the general office, right? So keep in mind, everybody in that office now we're now doing e-filing. We're now doing e-filing. It's no longer split up like it used to be, first filing, second filing. Everybody's in there doing e-filing. So we have a number of people in the queues. So anybody should be able to take that call. So I'll stop in there today and let them know that they're not being responsive. We want to hear about that too.
No, they were responsive when I got, I don't know if this was the
when
number
you finally get there.
I got the number, but the number I was given, you know.
Maybe
I gotta take this call.
That was a joke. Maybe
I gotta take this call.
That was a joke. Any other questions? I'd rather hit your questions in the back.
Hi, Mike. I'm Allison Block. I'm a Montgomery County attorney, old attorney, but new in Philadelphia. And we have map issues with filing in Montgomery County. Are there map issues in Philadelphia?
I haven't heard of any specific MAC issues. Same question, same issue?
No, I've never had any.
None? And you're using MAC?
Yes.
Yeah, I've heard of no complaints. So I think our system is compatible.
We can't use map in Montgomery County.
I have to call Mike Keys and talk to him.
Sounds like an antitrust violation to me.
But that's a good point. We do communicate with the court administrators in the other counties. Mike and I talk periodically. I'll mention that to them. Maybe the system is not as compatible.
I also do want to point out, within the materials is a list called From the Source, and that includes the link for the Court of Common Pleas e-filing manual, the link for the Court of Common Pleas forms, statutes, rules. So we've tried to compile a list of resources that you can use when handling different types of cases. Because this is a paper manual, we couldn't do anything with the link, but the link is all spelled out there for you. So that's a great resource, because I've seen the e-filing manual. It's pretty thick. So that's why we're fortunately not giving you that and killing all those trees. But you've got the link that will actually help you out. And we've also included several step-by-step guides on how to set up your own account and how to access certain dockets, whether it's family court, municipal court, or otherwise. We had a question?
And then our materials are going to be put up on our website shortly, and then that way we will have the links directly.
Yeah, so this manual will be available on VIP's website. We have another question here?
For filings due on a particular day, may they be submitted through midnight and still be considered timely?
11:59, and it's as of that date, 11:59 and 59 seconds.
Again, that's not for family court. Family court, the clerk of the family court's office is only open until 4.
You have to go in.
So you've got to physically go in and do it at this point.
Just a follow-up question to his question. You submit it at 11:50. It's going to be confirmed, but it won't be accepted until the next day. For some reason, it could be rejected. Would it be considered filed as the previous day, or when it's accepted?
It's filed when it's accepted and when it's paid for. If it's something that needs payment. In this case, most of your cases is probably IFP status, but it's filed when it's accepted. So make sure, be mindful of that when you're trying to get something through. Don't wait till the very last minute or till the deadline if you can. Now, if there's a problem, there's always a recourse. That's why we have judges. If there's an issue, you can always file a motion non-pro-tonque for the document to be accepted non-pro-tonque. And if you do that, you're going to have a document giving you an e-filing number where you attempted to get it through. So you just attach that and say, I tried to file it on this date and time. It was rejected for this reason. So if you get into a jam like that, then you just file a motion and ask for reconsideration and that the document be accepted non-pro-tonque. But attach the information that you get from us. That's one of the reasons why we give you that e-filing number. You have proof that you attempted to file it the day before, and then we rejected it on our end. Because our clerks, we all make mistakes. You don't want to know how many I make a day. But we all make mistakes, and if our clerks wrongfully reject something, you need recourse there. That's why we give you that information. And proof that you tried to get it in and somebody rejected it.
So be mindful of that when you're sitting on the beach in the Caribbean. If you want to get that document filed, give yourself a little bit more time. So other than keeping track of dockets to keep track of what's going on with your case, Regina, what other suggestions do you have to stay in the loop with what's going on with a particular case?
Well, obviously the e-filing has been a great help, and you're getting emails all the time as to anything that's going on, so that's wonderful. But in terms of civil cases, you still have to go back to basics, and you have to maintain your client communication. You need to meet with your client, obviously, and really discuss with them the nature of the case, what their role is, what your role is, what the expectations are. And of course, that varies depending on what the case is about. You know, in our practice, we do a lot of product liability and medical malpractice, and it can be a long process. And you really need to really have an understanding with the client that what the process is, what role they're going to have, that they're going to have to participate to some extent in terms of discovery and depositions and that kind of thing, and that there's a lot of things going on behind the scenes. You know, this is all new to the client, and it's something that you're more experienced at because we do this for a living, and oh yeah, there's a deposition today, we have discovery tomorrow. But to a client, it can be very overwhelming, especially if they don't have an understanding at the outset of what to expect and how things are going to progress. So, I mean, I can't emphasize enough client communication. And that can be done not just in person, but of course you should have some initial meeting in person, but by phone. It's certainly appropriate to update them periodically by phone as to what's going on. I would recommend, if you have substantive phone discussions with your clients, and I know this sort of sounds basic and I see a lot of seasoned people out there, but I have to tell you, when I was preparing for this presentation, it did bring it all back to me and made me feel good, like, okay, we got to remember to do all this. But when you have phone conversations with your clients, you should really make memos to your file. And there's multiple reasons for that. Number one, we don't all remember what happened. I don't remember what happened yesterday half the time, and I may not remember some critical discussions that we had or some nugget of information that the client shared with me a couple months down the road. So if I've done a memo to the file and I go back, it certainly refreshes my recollections and my memories. But in addition, as I mentioned earlier, if for some reason you're no longer able to continue on that case and someone else is going to step in and take over, or for some reason someone has to cover something for you in that particular case, there's an opportunity for them to look in the file, get a sense or a flavor of the client or of the issues or what is transpiring in the case. So it's very critical that in addition to having the verbal communication, you make some sort of memo of it to your file. While we are in this electronic world, and it is a wonderful asset, although I have to tell you, Charles, sometimes when you get those emails about some activity on your case, you get a little bit of a pitter-patter in your heart, like, uh-oh, what's going on? You still have to do some written correspondence. You still have to send letters confirming meetings or giving them an update in writing, and you need to maintain it for your files. You can certainly use email, obviously, that is a great way of communicating, but you need to have some method in place by which you're going to maintain and retain the email files. I'm not yet a great computer techie person, but I have figured out how to make folders for each of my cases and keep the emails in the folders. Some of the emails you really should make a hard copy and keep in the file as well for those instances where someone else, again, may be coming in and helping out in some fashion. So in terms of the civil cases, those are the most critical ways of keeping your client in the loop as to what happened.
Regina, can I chime in on the memos to the file, too? Sometimes over the course of time, you see a creep in the client's version of events. And if the version of events begins to evolve, it's important for you to know that, to test credibility, to see if somebody's version of the facts is changing. If they're changing it with you, they could be changing it in the world at large. There could be lurking credibility problems, and you need to be on top of that. Because when we talk a little bit more about advocacy generally, we're going to talk about the utter importance of credibility in a case and how failure to be credible with the court or with the jury is fatal. And sometimes clients will begin to wander, and I think it's important to be able to bring them back and say, gee, not in a confrontational way, but say, I think I'm confused. I thought that when we discussed this before, X, Y, and Z was true. So,
I would also jump in really quickly on your phone conversation comment, which I think is great. Sometimes low-income clients are dealing with various stressors in their lives. They may be choosing between which bills to pay at any given moment. And if you're choosing between, for example, paying for food or paying for electric versus paying for your phone, oftentimes phone doesn't win. So it's important when you're working with a pro bono case for a low-income client to remember to express to your client, I need to keep in contact with you. Please let me know if you think you won't have phone service for some time, or get in contact with me in some way. If for some reason I can't reach you by phone, I'll send you a letter asking you to call. Sometimes I've had clients with phone service that's gone out. In those situations, typically what I do is send a letter and advise my client, if you have a trusted friend or family member that I can call and leave just a message, basic message that says, I need to talk to you, please call me at, and my phone number, that would be helpful to me. And that really does help maintain the communication between client and attorney. It's very important, I think.
And one of the things that Regina had mentioned earlier was making sure the client understands what the process is. Well, if you're not sure what the process is going to be for your particular case, let us know, because we will try to hook you up with a mentor who can work with you to get you the understanding of what the procedure is so you can explain it then to the client. So we're the VIP, the Support Center, and the other legal service agencies in Philadelphia are always very supportive of our volunteers. We want to make sure that you all have the resources you need to represent these clients. And if it means, for example, me sitting down with a volunteer or talking to a volunteer on the phone, explaining what's going to happen for every step of the way for a support case, I'll do that so then you can turn around and give that same information to the client. You'd rather have it, the client would rather have it come from you because you're representing the client, and you need to know, understand the process. So we have no problem explaining it to you so then you can explain it to the client.
I have a question. Regarding e-filing, now that everything is done through e-filing, I have some clients that always want to have a copy of everything that gets filed in court. And although you can enter an appearance of record and get everything sent to you whenever anything changes in court, is there a way to set up that the client could also get the same messages, or would you be able to forward that to the client to save on paper? Because maybe they want to see everything, but really they don't want to have all that paperwork that may or may not pertain to them.
Well, keep in mind, in the e-filing system, you have in the civil e-filing, you have the opportunity to put in 3 email addresses.
Okay.
So if you wanted one of those email addresses to be your client, so that your client is notified of everything that happens in the case, that's probably one way to do it. The other thing the client can do is go to the civil docket, public access civil dockets, and keep track of what's going on in the civil docket.
So that would be something that they would have to do themselves. It wouldn't be set up automatically unless you included them as one of the email.
That's correct.
Okay.
Now, if you wanted to take one of your slots and give it to your client, give me your email address, you could do that. And then they would be notified of everything filed in the case.
I just want to put the question to the panel, like, have you had that experience with clients wanting to have the electronic version sent to them, or what do you do in your practice?
I really have not had that experience in my practice where clients want that detailed information. I mean, you know, on occasion you have a client that is intimately involved in the case and they want updates, you know, weekly, if not daily. And fortunately with email you can do that without, you know, taking up all the other time from your other clients. You know, if I have a client that wants that kind of stuff, I may let them know this is what's getting filed, and you know, if you'd like a copy, I'll send it to you. But I guess fortunately I haven't had one that wants to be, you know, with me every step of the way. And I actually had some clients that have been attorneys, and even in that instance, they don't want that. You know, in civil cases, and depending on the nature of the case, they're almost happy that someone is now helping them and they can step back from the process, at least in the nature of our practice. So I don't know what advice to give you, unless if they really want that, maybe they could be included on the email. Because often then when they get that, it becomes confusing, or they don't understand, or they're going to, you know, focus on something that, in terms of the big picture of the case, isn't as critical, but they aren't understanding that, and then it takes away from the ongoing process of the case. I don't know if either of you have had any experience along these lines.
Well, you know, in family court, nothing is e-filed. So what I've always done with my private clients, and also clients that I'm handling through VIP, I will always send a client a copy of whatever is filed with the court, because I want the client to always have a copy of it, so they can never say, I didn't know about this. Now, it's not as many filings as there would be in other traditional civil matters. There's usually whatever pleading gets filed to start the action, and maybe a responsive pleading, and then all court notices. Again, all this stuff is going through the mail. For some clients, I will scan them and then email them to my client and save on the postage and save some trees, but there's no automatic system. I did want to add one additional comment to follow up with what Charles had said about having 3 email addresses to send information to. Please, unless someone from the legal service agency specifically says to be included as one of those email addresses, don't include us. We have a lot of cases, so we would want to be getting our email boxes filled with the updates on the cases that you guys are handling. Unless a staff member specifically says, yes, include me so you know what's going on, please don't do that. So we've danced around one of the issues a little bit, but let's get into a little bit some more of the detail, which is how cases actually get started. What gets filed, where does it get filed, how does it get filed? We alluded to some of it talking about e-filing, but let's go into a little bit more detail. Regina?
Well, in civil cases, you know, there's sort of 2 components to starting a case. One is what we've talked about a little bit in meeting the client and examining records or evaluating the client and the situation and determining if there is a case. Once you've determined that there's a basis for a claim, then you have to institute suit. And you can do that one of 2 ways. You can file a writ of summons or you can file a complaint. In civil cases, generally, we try to file a complaint, but there are instances where you may need to file a writ of summons because the statute is looming and the client just came and you think it's a valid case, but you really haven't had the time to get all your ducks in a row, so you may start with a writ. A writ is a document that will toll the statute of limitations, you have to serve the writ, and you will have to get the complaint filed in a timely fashion. The second method is the complaint, which we've just discussed, and that would be the document that you would prepare to start the suit. There are a multitude of rules in the Pennsylvania Rules of Civil Procedure that walk you through the process and, set forth how the pleading needs to be prepared and that kind of thing. But given the e-filing system and the Philadelphia Civil Manual, there are many forms in there that are very useful as well. One thing to keep in mind when you've instituted the action by complaint, you need to include what's called a notice to plead, because by filing this and serving it on the defendant, in my instance, the notice of plea tells them that they have to respond to this document. If you don't file the notice of plea, it's not properly filed, and I'm sure you would get some email from the courts advising you of that. But before that system, it was critical that you include that. Once you file the writ or the complaint, I've been talking about this service, which seems like no big deal, but it's critical that you have this properly served on the opposing party. You have 30 days within which to do that. If for some reason you can't locate the defendant and you can't get the service effectuated, you can reissue the writ, or what's the proper term for the complaint?
Reinstate the complaint.
Reinstate the complaint. And that will then give you another 30 days to do that. But you've got to make sure you get proper service, because if you don't, then there's a possibility that the case will not be able to go forth. So that's how you would initially start in a civil action. And additionally, we talked earlier about the entry of appearance. At that juncture, you would file your entry of appearance because you're now instituting the suit. Before that, you may not know if you had a basis for a claim, but you've got to file your entry of appearance. I'll turn it over to you for the foreclosure process.
Sure. So with foreclosure cases, again, like I said, we have two different systems. We have negotiations and we have litigation. Foreclosures proceed like any basic civil action. A complaint is filed. We handle at VIP, we handle foreclosure defense. So we wouldn't be filing the complaint. We would be responding to the complaint with preliminary objections or an answer, or just assisting the client through negotiations without filing anything at all. If you are participating in negotiations through Philadelphia's residential mortgage foreclosure diversion program, as long as you are within that program, you can still file a response to the complaint. So the 20-day period that's classic for responses to civil complaints, it isn't necessarily told. It can still expire, but as long as you are still within the diversion program, you can still, past the expiration period, file an answer to the complaint. Should I pause here for a moment?
Yeah, I'm going to pause for a moment. I just want to introduce everyone to the Honorable Allan Tereshko. I think Judge Tereshko is the perfect person to speak to you guys this morning, because while Judge Tereshko is currently sitting on the civil side, he also has experience on the family court side, because I remember some of the cases I've had before Judge Tereshko in the past.
Sure. Thanks. I'm glad you had that step. I wasn't about to make that. Are we good?
So, Judge, any comments you'd like to offer?
Sure. Just following up on your comment about being in family court, I started out as a child support master in family court in 1980, and then became the chief master in '84. And while we were there, we set up the Masters in Divorce program, which did not exist, expanded the child support program from one master, me, to 4 masters. Then we, near the end of my tenure there, we developed the Masters in Custody program. When I went on the bench in 1990, I stayed in family court and was there for 8 years until '98, obviously, and then came to the civil side. So I've had the experience of practicing in that area and in this area, and I know of your good works on the Child Support Center My wife is a child advocate. She's a full-time medical malpractice defense attorney with a very busy practice, yet she finds time to take on cases. She took on a case 3 years ago involving a child who had been taken by DHS, and after about a year and a half, I'm happy to say that there was a reunification goal and the family was reunited, and to the best of our knowledge, the family is still intact. She took on another case about a little more than a year ago, and in this case, it's working out, but in a different way, because the mother's parental rights have been terminated, and there's been a goal change to adoption, and we're there, and they and the child are on their way to forming a new family. So my experience with what you do is firsthand. On the civil side, just some good news about our programs. As you know, we're a court-driven system, which means that we set deadlines and not the lawyers, and we expect all of the lawyers to conform to our deadlines in moving cases through our civil side. As the incoming supervising judge of the civil side, as an incoming manager of anything, it's always a good idea to conduct due diligence in the program that you're going to be supervising. And we started a due diligence review in our civil programs, and of course, the due diligence review is made a lot easier because of the incredible resources we have on the civil side, and I'm sure Charles spoke to you about some of those resources. But having the banner system that we have, the court management computerized system, which, by the way, is a system that we manage in-house. If we need to develop a different program, we have the resources to do it. We have incredible talent in the program. All of our managers in the civil side are very responsive, very knowledgeable, and if we need to do that kind of due diligence, it's a matter of going into the system and mining the data, which is always there. And the analogy occurred to me this morning about I just got an iPhone and I have a Siri on it, the Siri application. So I'm thinking to myself, how cool would it be to be able to pick up a phone and say, Siri, tell me if we're compliant with the ABA standards in our major jury civil program. And then I'm getting the word back from the lady in Siri, and she says, Alan, it's going to take me a few minutes. But that's what we do. That's the kind of resources that we have. And if you're not aware of all the programs that we have on the civil side, it's really interesting to look at our civil manual, and it outlines many of the programs, one of which you're heavily involved in, and that's the mortgage foreclosure program. We've looked at it recently. We went through the inventory, and we were up around 9,000 cases, and that went from 10% to 11% of our total inventory. So we went through it. We decided that we had not conducted a sweep out of all the old programs, and under one of our civil rules, we're able to remove cases in which there has been no activity in 24 months. So what we did was we ran a program. We eventually wound up removing about 2,200 cases that fit into that category, and we make sure that all of the steps along the way, which gives due process to all the parties involved, have been complied with. So I think we're now down to under 6,000 in our foreclosure inventory. That inventory kind of takes care of itself because of the built-in